I think we will start now. 6:05.
Yeah, I think we better start.
We can let people join in as we go. Okay, dear participants, hello and welcome to this Majeure Company live session on commercial contracts. We appreciate you joining us in this very difficult time for our country and the rest of the world. The purpose of this session is to discuss some of the most common clauses that we find when drafting or reviewing commercial contracts. It will obviously be impossible to cover all clauses in the limited time that we have. So we have selected the ones that we thought are most common and as such would be most useful to talk about. It will also be difficult to have in-depth discussions on any of the clauses. So we'll try to stick to the main points of consideration when drafting or negotiating each of these clauses. So before I introduce ourselves, I would just like to let you know the house rules. So the session will last for 2 hours. The last 15 to 20 minutes of the session we will keep for Q&A. And in order to keep to the time, we have a lot of content to cover. So we will not take questions, unfortunately, while we're speaking. But if you have any burning questions or comments, or if you have any technical issues like you can't hear the audio or something like that, please let us know through the chat box and keep the questions coming on the chat box. I'm sure you can find it on the bottom right corner of your screen. So without further ado, I will introduce our speaker, Barrister Ahmed Zakir Chaudhary. Zakir works at Dr. Kamal Hossain and Associates, which needs no introduction. He specializes in commercial law, financial regulations, M&A, and corporate transactions. And we'll be conducting the first half of this session today. The second speaker is me, Barrister Saqib Mahbub. I am a corporate and commercial lawyer working at Mahbub and Company. My areas of specialization are corporate and regulatory affairs, international trade, banking, and employment. At this point, I would like to give the floor over to Zakir to start the session, and I will join you for the second half of our presentation. If there is any issues with the audio so far, can everyone hear me? Just yes on the chat box would suffice. Okay, great. I see one yes, so I'll take that as a yes for everyone. I see more yeses. That is great. I see some familiar faces, which is fantastic to have. Okay, Zakir, over to you.
Thank you, Saqib. Can everybody hear me? That is just confirming. Okay, good, good, good. Thank you very much. Thank you for the confirmation. Hello, I'm Zakir. Thanks, Saqib, for the introduction. Today's session is about commercial contracts. So we'll dive straight into it. I will keep the discussion very general for the first few minutes because I believe there will be more people joining in. So just so that they don't miss out something very important, I'll keep it very general for the first few minutes. What are commercial contracts? Let's start with that. Commercial contracts are just like any other contracts. Most of us know what a contract is. So we have I presume that we have dealt with some sort of contract in our daily lives. Commercial contracts are contracts which are basically any contract which is dealing with a business situation. So, for example, it could be many different types of contracts. For example, a sale of goods, sale of property, sale of shares, sale and purchase of services, employment contracts, joint venture contracts, lease of property, etc. So there is no fix. The thing to take away from this slide is to understand that commercial contracts don't have a fixed definition anywhere. These are contracts just like any other contracts. The only distinguishing feature these contracts have usually is they are made or executed or performed in relation to business situations. Like any other contracts, commercial contracts are binding documents. And the parties can be anywhere between two and upwards. It can be two or more than two. It could be five. It could be 10. There's no upper limit to the number of parties that could be involved in commercial contracts. So, what are the basic features of commercial contracts? The basic features of commercial contracts are the same as any other contracts. There has to be offer and acceptance, like any other contract. There has to be free consent of the parties. Um, so the consent that the parties, the offerer and the acceptor are giving should be free of any coercion, undue influence, misrepresentation, or any other external influence. So that is one of the requirements for a valid contract, and that is also one of the requirements for any valid commercial contract. The parties to the contract must be must be competent. What we mean by competent is not the ordinary sense of the meaning of the word competent. The competent in this context means the parties have to be a major in the sense in Bangladesh law. Under Bangladesh law, a person would become a major at the age of after attaining the age of 18. Before that, a person remains a minor and they would not be competent to enter into a contract. There is another requirement, is that the party has to be a legal person. So it can be either an individual or it can be a company. However, it cannot be, for example, a proprietorship. In case of proprietorship, the proprietor has to be the party in the contract. And there is a common misconception I've come across where the contract is done in the name of the proprietorship. It is not fatal to the contract, but when you do it in the name of the proprietorship, it is actually the proprietor who is the party to the contract. So it has to be either an individual or it has to be a corporate entity which is capable of entering into the contract. The next up is the lawful consideration. The consideration has to be lawful, in the sense that you can agree to any consideration. Consideration is, I hope everybody knows what consideration is, but I'll just briefly gloss over it. Consideration is what you pay for the product or services under the commercial contract. So, for example, if you are buying cotton under a contract, whatever you pay for that cotton or that product is the consideration. The requirement is that the consideration, whatever you pay for the product or service, that has to be lawful. Most of the things we think of as payment are lawful. So when we go to a grocery shop, we buy something, that is also a commercial contract. We pay in cash, that is lawful consideration. What if we offer to pay in something unlawful? We offer an unlawful service, or we offer to pay in a commodity which is itself illegal. For example, drugs or cocaine. That would be funny, but what if somebody wanted to do that? That I have a lot of drugs, I'll give you drugs for cotton. That would be unlawful consideration. But these things are not common. These are not common scenarios. But what happens is in everyday commercial context, we often find the parties sometimes tend to agree to pay in a foreign currency. So if both the parties are in Bangladesh and the parties agree to pay in USD or pound sterling or any other foreign currency, that is not lawful consideration under Bangladesh law. If the products or services are being procured or bought in Bangladesh, the payment has to be in Bangladesh taka. That's not to say that you cannot agree to pay agree the price in foreign currency, but when it comes to payment, you have to pay in equivalent Bangladesh taka. So a party which has um, agreed to pay in foreign currency, that would be an example in an everyday commercial context of unlawful consideration. The price must be paid in Bangladesh taka if the parties, if the products or services are being purchased in Bangladesh. The next requirement is lawful object. So the contract must have a lawful object, um, in the sense that you're trying to do something lawful. It cannot be a contract to obtain drugs. It cannot be, and this is something which I have advised on extensively in the last 1 year or so. I have had many gambling service providers coming to me and asking whether they can provide gambling services, whether physically or online, whether they can provide gambling services in Bangladesh. And as you, if some of you may know, that gambling services are illegal in Bangladesh. We have restrictions or a duty imposed on the state to curb gambling activities under the Constitution of Bangladesh. So not and things did not stop there. We have specific laws which prohibits land-based gambling. We have we don't have a direct law which prohibits online gambling. However, we have Bangladesh Bank circulars which restricts payment, which does not restrict, which prohibits payment to online gambling service providers. So in this scenario, entering into a contract with a gambling service provider would be contract which has an unlawful object. You cannot have those sort of contract. You cannot have contracts which purports to purports to achieve something which is not legal under Bangladesh law. So it has to be a legal purpose. So you can go for, you can buy services, products which are allowed under Bangladesh law. So that one has to keep in mind when entering into a commercial contract. Can can contract be oral? Does it have to be written all the time? It can. The short answer is yes. A commercial contract may be oral, and uh, but in everyday commercial context, you would you would find that most of the parties would prefer having a written contract. There is a couple of reasons to it, but let's start with oral contracts. Most of the commercial contracts are in fact oral contracts. In at least in that is true at least in Bangladesh. That is because if think about everyday scenario in your life. You go to a supermarket, you pick up things you like, you pay for it. You don't have any written commercial contract with Shopno, Arong, or Mina Bazar, Agora. You don't have written contract with any of those supermarkets, but you are entering into a contract that is a valid contract. But ultimately, we do not insist on, and neither of the parties insist on every day are written contract. This is because oral contracts have definite advantage over written contracts in the sense that oral contracts are easy to enter into. They are fast, they are efficient, there is no time lag, there is no negotiation regarding the terms of the oral contract. We kind of have an implied understanding of the social situation in a supermarket, and the parties know what to expect. So oral contract in that sense, in that scenario, just slows things down. So that is why, um, since the parties are already under an implied understanding about what to expect, so the customer goes with the product in the cashier, in front of the cashier. The cashier scans the product, customer pays, customer walks off with the goods. So the expectations are quite clear. The social obligations on social and legal obligations of both parties are very clear in that scenario, which is why written contracts could be inefficient in this scenario. But and these kind of oral contracts constitute most of the commercial contracts in our everyday lives. So you um, uh, come out of the supermarket, you go to the pharmacy, again you will encounter oral commercial contracts. Even if you hire an Uber for business purposes, you going to a business meeting and you are hiring an Uber as your transportation. That is also that could be one sort of oral contract, because although Uber has extensive ride sharing policies, but when you enter into a contract, you don't have a written contract with Uber or the driver, but with it does have certain there are this is example of a scenario where the main contract is oral, but before you enter into an oral contract, you actually agree to a set of written policies. So that is another scenario where um, uh, the contract could be a mixture of oral contract and a written contract. But in corporate world, um, most of the commercial contracts you would find are written contracts, and written contracts is the flip side of the coin. It is although we have seen that written contracts takes time. Written contracts require substantial negotiation between the parties. Sometimes the negotiations are quite lengthy and time consuming, but written contracts have their own usefulness, in the sense that when parties don't know what to expect from one another, or it is not a familiar business situation, it is better for the purpose of certainty. And this is something I would request everyone to remember, that written contracts promote certainty of what to expect bit of one another. So parties who do not know each other, parties who are dealing with an unfamiliar business situation, and they don't know what are the terms. What the terms of the contract are not established by way of convention, as in the case of a supermarket. Those are the situations where written contracts have a definite advantage over oral contracts. Written contracts will be elaborate. It will have most of the written contracts will have all the terms and um, timelines of performance of the contract. So it doesn't. The question, the question: can contracts be oral? Yes, it can be. Can contracts be written? Yes, it can be. Can it be a mixture of both? Yes. There is no restriction on the form of the contract, but we have to keep in mind about the situation we are dealing with, and we have to keep in mind whether an oral contract would be more beneficial or a written contract. And as lawyers, you would be faced with written contract almost every time. And written contract have written contracts and oral contracts have their own advantages. That is the thing to take away from this. Can contract be unstamped? So many of us have already entered into um, contracts in our daily lives. And some of us may have written contracts printed in stamp paper. The reason we go sometimes execute contracts in stamp paper is because there is a stamp duty under Stamp Act of Bangladesh um, um, to be paid for any agreement. And the stamp duty is for general contracts is 300. There are contracts which requires a certain percentage of the value of the consideration. For example, share purchase agreement would be 1.5% of the value of the consideration you pay for the shares. So there are both there are different types of agreement which attracts different type of stamp duties. What if the contract is unstamped? Um, what are the consequences? If you pay the stamp duties, well and good, you're good to go. If there is no payment of stamp duties, it does not, the thing to remember is it does not invalidate a contract. The contract is still valid, it is binding, and it can be enforced in court. However, before this unstamped contract or agreement is tendered as evidence in court, the stamp duty has to be paid. So that is the only consequence. Up and until the stamp duty is paid with regards to the agreement, the agreement cannot be used as evidence in court. So one of the reason people enter into written contracts is not because only written contract would promote uncertainty. Rather, uh, there are other advantages as well. If you have a written contract, you have a piece of document, and the documents have all the terms and conditions which were agreed between the parties. If one of the parties fail to adhere to the contract, fail to perform the contract as per the terms and conditions in the written document, the other party would, of course, in other words, this is a document which is binding. This is enforceable in court. That is why people enter into a written contract. It promotes certainty, and you have a written document which you can go and enforce in court if the other party is not complying with the terms and conditions. Um, for unstamped contracts, the consequence is if you don't have it stamped, you cannot um, go and tender this agreement as an evidence. So, for example, if the other party has not complied with the contract, you would ideally want to file a suit for compensation, damages, whatever you call it, or for specific performance. I will discuss these two options in the later slides. But you would want to file a suit and get some remedy from court. And one of the things you need to prove is A, you had a valid agreement with the other party. And when when you would want to prove that uh, element, you would want to have that written document tendered as evidence in that particular suit or legal proceedings. That is something that is where you would face a certain challenge when you don't have your contract stamped. Before you do that, you have to get it stamped. So why have unstamped contract at all? And we do have unstamped contracts, and it is quite common, especially in cross-border context. When we have parties from two different jurisdictions, we often have the contracts unstamped, and we do not stamp it at the time of execution. There are a couple of reasons for it. One reason is logistical hurdle of getting unstamped or unused stamp paper outside Bangladesh, which is considered as a security, and it is for the Bangladesh foreign exchange regulations has restrictions on sending securities from Bangladesh to outside Bangladesh. So that is one practical difficulty of sending unused stamp paper outside Bangladesh. Other than that, if you have two parties from two different jurisdictions, they may have two different set of requirements for stamp duty. For example, if a Bangladeshi party enters into an agreement with a Thai party, um, it would be difficult to ascertain which stamp duty, the Bangladesh stamp duty or the Thai stamp duty would be applicable on the agreement. Even if we do have agreement between the parties as to which law should, which stamp duty should be applicable on the agreement, and it is possible to do so. It can be the situation can be that either of these party would be required to go to the court to enforce this contract. So in order to avoid delay or substantial or lengthy negotiations about which stamp duty would be applicable, we keep it unstamped. Most of the cross-border commercial contracts we execute remains unstamped at the end of the day, and parties accept it as it is, and with the understanding, of course, that if and when required, stamp duties would be paid before this document is used in evidence. So we have a unstamped contract as well in commercial contracts. Can the contract be unregistered? Yes, of course, a contract can be unregistered, and in fact, many of the commercial contracts are unregistered. Be sometimes because um, the contract doesn't require registration. So when I say require registration, there is a Registration Act in Bangladesh, and it has a list of contracts or agreements which must be registered. And one example of one such agreement would be any agreement which deals with rights in an immovable property. So if you have any contract which gives you rights over an immovable property, that is mandatorily registrable under the Registration Act. What if you do not? What if there is a contract which is mandatorily registrable, but you do not register it? What is the consequence? In that case, the contract becomes unenforceable. So it is close to being useless, because if you can't enforce a contract in court, you kind of lose the utility of the written contract. So if the Registration Act says that a particular type of contract is registrable mandatorily, you have to register it. If you buy a land, if you sell a land, if you buy a land, or if you enter into a lease agreement, which is which has a duration for more than 1 year, that is a contract which is mandatorily registrable. So sometimes we do face challenges for contracts which are uncommon but mandatorily registrable. For example, towards the end of last year, we had one of our clients, which is a multinational banking company. It came to us and it wanted to enter into a lease agreement for one of its offices in Dhaka, and the duration of the lease was more than 1 year. So we advised our client that if your lease is more than 1 year, as per the Registration Act, you should get it registered because it's mandatorily registrable. And when our client, based on our advice, approached the landlord was taken aback, and he was surprised, and he was scared to enter into a registered agreement. The reason being the local landlords are usually used to going to the sub-register for the purposes of transfer of immovable property. So if they want to sell or purchase immovable property, land, building, they usually go to the sub-register. That is the only situation, only known situation for them where they would require registration. However, my client in this case was going for a lease of, I think it was 5 years, and the landlord was um, quite nervous in the sense that why would we want to register this, and um, we kind of had to explain to him the law. We provided an opinion, and he consulted his own counsel that this in this scenario, in order to perfect this lease agreement, you need registration. And ultimately, he agreed. That was the first hurdle we faced. What was more surprising is when we went to the sub-register, and the sub-registry itself is unfamiliar with this type of arrangement where there is a lease agreement and the lease agreement has to be registered, because not a lot of people enter into a registered lease agreement in Bangladesh, even if the law requires that any lease agreement over 1 year would be registrable. It's still very uncommon, and it was very uncommon for the sub register as well. So we had to kind of explain the law to the sub registry. We had to refer to the legal provisions, and they had to actually internally consult amongst themselves. They had to go to the high ups and find out for the first time, in that particular sub registry at least, that these lease agreements could be registered and what would be the applicable stamp duties in those cases. But ultimately we got it done with some delays, but it was ultimately done as per the Registration Act. So contracts can be registered when, and it has to be registered when it is mandatorily registrable. But the vast majority of commercial contracts, these are not mandatorily registrable. If it's not mandatorily registrable, you can still register this contract before the sub-registry. However, you have to pay the applicable stamp duty, whatever is provided in the schedule of the Stamp Act of Bangladesh, and you can still register with a registration fee, but you don't have to, because these are optionally registrable commercial contracts. If you do, it's your own choice. If it's party's own choice. If the parties don't want to register an optionally registrable contract, they may skip this process altogether. They can just print the contract in a stamp paper and execute it, and this will be a valid contract and it will be enforceable without any further formalities with regards to this particular agreement. So um, the thing to remember is when you do when there are parties, there are parties to a contract, and they have uh, they are negotiating. The parties are free to negotiate any terms they like, subject to the law. So they can't agree to something which is prohibited by the law. For example, you cannot agree, the two parties or two or more parties cannot agree that one party would be unable to sue the other party, sue or bring legal proceedings against the other party. That is something not permissible under the Contract Act. This is not permitted. Or any other, for example, I gave you an example before that you cannot agree for services, gambling services, because that's not lawful under Bangladesh law. So parties are free to negotiate terms of the contract, free to agree to anything, provided it's legal, it's permissible under law. The other thing that the parties cannot agree to is if one party enters into another into an agreement with the other party, whereby one of those parties are restricted from pursuing a lawful profession. So that is another example of a unlawful contract. In those cases, the contract would be void and it would not be enforceable. It is as if this contract has never happened. So I'll quickly gloss over some of the components of commercial contracts. Um, Keep in mind that these are not mandatory things. The mandatory features are this slide: offer, acceptance, free consent, which I have dealt with. The next ones I'm looking at now are common things, common attributes to commercial contracts, which you can have, which you may skip altogether sometimes, and it doesn't have to be the way I'm showing you, but I'm just showing you the common form of these components. The first up is the title. Title is important because title gives you an idea about what the agreement is about, but um, the name of the title does not determine what kind of contract it is. Finally, and without any argument, sometimes the contract is named one way, but the purpose of the contract is something else. If there is a conflict between the name of the contract and the substance will prevail over the name. So if it's called a share, I encountered a share purchase agreement few years back as a draft from a client for vetting. This share purchase agreement turned out to be a power of attorney, and we renamed it during our vetting as power of attorney. So this was basically not a share purchase agreement. It was something to do giving a power, one party giving a power to another party to deal with the shares as they seem fit, like a power of attorney. So if there is titles are important to give you an idea about what the document is about. However, if there is a conflict about over substance and form, the substance will prevail. Um, then you have the parties, and we have touched about the parties a bit in our previous slides. The parties have to be parties competent to enter into a contract. So it has to be a person who is above 18 years of age. If it's an individual, you give the name, you give address, and any other information which will enable you to identify that individual. If it's a corporate entity, usually the name of the corporate entity, um, the registered address of the corporate entity, or any other business address of the corporate entity, and a person who would be signing on behalf of the corporate entity. So the best person to sign on behalf of a company would be the managing director, because the articles of association, most of the articles of association are in Bangladesh, authorizes managing director to enter into contracts on behalf of the company. He doesn't require any other additional permission. So if you have a company and the managing director is representing it, you don't have to look further. And it is a common understanding, or it's a common parlance, that managing director would have this authority to enter into a contract. What if the managing director is not available? In that case, somebody else can represent the company. However, in those situations, you may need to insist on finding a specific authorization where this particular person was authorized by the board of directors to enter into a contract. It could be any other director, it could be a manager, it could be one of the employees of the company, but he has to be authorized by a board resolution, or authorized in a meeting of the board of directors to enter into this particular contract on behalf of the company. So after the parties, the in some of the commercial, and this is not again, this is not mandatory, but some of the commercial contracts have preamble or recitals. We use this preamble and recitals words interchangeably. This is where this is not part of the contract, and this is not where uh, the mandatory terms are set out. This is just a good summary sometimes, and it's very helpful to set out the context, the background, or the background facts in which this commercial contract came into being. For example, whereas one party distributes mobile phones and the other party wants to purchase those mobile phones, therefore these two parties enter into this contract under the following terms. This is how it goes, and then you set out the mandatory terms. So what is the use of this preamble? It sets out the background. It kind of summarizes the intention of the parties, and it summarizes or sets out the assumed facts. And this is important. So in my example here, one of the parties we have assumed the fact that one of the parties is in the business of selling and distributing mobile phones. So this fact is the assumption, background fact, in the context of which this commercial agreement would be entered into, and the other party wishes to purchase those products. So it is kind of an indication of what was the parties doing, or what were the parties doing before entering into this contract, and how this contract came into being. After the preamble, um, the the commercial contracts, modern commercial contracts, you usually have definitions, and definitions are important because, remember, one of the major reasons why enter into written agreements is because um, written agreements are promote certainty, and definitions are the key instrument in the written document which promotes certainty further. In the sense, look at these examples. uh, these terms will come up in the contract, in this particular contract, more than one time. It will come up again and again and again. So these terms, if defined, will not will not give rise to any dispute as to what it means between the parties. So more definitions you have, more defined terms you have, you are promoting certainty. Um, for example, if the agreement refers to an act, it will always mean Companies Act 1994, unless it says if it refers to any other act, it has to give the full name. If it only says act, section 44 of the act, it means section 44 of the Companies Act. It cannot mean anything else. So that is the purpose definitions have in written agreements. It promotes certainty. So whenever there are more definitions, the chances of disputes regarding meaning of terms reduces. So there are less disputes between the parties. Parties know when they talk about a term, when they refer to auditors or board or business day, they know what they are talking about. So especially business days. For example, business days is important because when there is a cross-border contract, business days may mean different things to different people. But in Bangladesh, as you know, probably, that Fridays and Saturdays are weekends. In other parts of the world, Saturdays and Sundays are weekends. So business days differ depending on which region we are talking about. So it's better to have a definition of business day in the contract so everybody is clear what they are talking about. In this particular contract, Fridays and Saturdays were weekends, so the remaining days are business days. So there's no confusion about what a business day means. Next up is the consideration, and I think this is one of the most important um, um, terms of the contract, because this deals with the payment. And for commercial contracts, ultimately, one of the parties is providing something, and the other party providing the service or goods requires payment. And this consideration, the term dealing with consideration deals with the price of the product or service. It does not only deal with the price, it sets out the currency. It sets out a mode of payment. So mode of payment means whether this price would be paid in cash or check or LC. So whatever the mode of payment is, it is better to set it out in the consideration clause. Dates of payment. When will this payment made? Oftentimes in commercial contracts, payment is not made at one go. It is made in tranches. So when are these tranches or installments are going to hit the bank account? It is better to have an elaborate, clear clause regarding consideration, because this gives rise to many of the disputes under commercial contracts, because ultimately commercial contracts are about money, payment of it, and sometimes it's not only about the money, it is also about the time when this money was paid. So for example, I have as many disputes about non-payment as I have regarding payments which were delayed. So it was not made in time, and there is a time value of money, and people claim interest that you made a delay, that delay caused these damages, plus I want some interest on the delayed payment. So these are proceedings which are also very common. So you have to set it out very clearly in the agreement, and there is example here um, of a consideration clause where the prices are being agreed and how it would be paid and when it would be paid. So keep in mind that when you deal with consideration, you set it out very clearly and elaborately, so that you um, um, uh, kind of avoid future disputes. And another thing which is not here, I think I should have included in on hindsight, is that when you deal with consideration, also deal with tax issues. Who is going to pay the tax which may apply on the consideration, on the purchase price? It's better to get it agreed at the outset in the agreement, so there is no lack of clarity in that regard. um, After the consideration, there may be conditions of the contract, and conditions are the fundamental uh, terms of the contract. So for example, if you're buying mobile phones, you would condition could be the mobile phones are unlocked or could be used in Bangladesh. So if they're not if they're unlocked for Bangladesh, or if it's not usable in Bangladesh, that could be a condition that these mobile phones you are giving me has to be in such a condition that it can be used in Bangladesh. If it's not, you'll kind of lose the utility of the mobile phone. These are conditions, are terms which are of fundamental importance. So if the condition is not fulfilled, you kind of lose the utility of the contract itself. So these are um, um, uh, very important terms of the contract, and it can be of two types: condition precedent and condition subsequent. Condition precedent is oftentimes you would agree to a contract, however you would agree to it in such a way that it would be effective if one of the parties can fulfill a condition precedent. What is a condition precedent? I can give you an example. For loan, a loan, a Bangladeshi person getting a loan from foreign country, it requires prior permission of Bangladesh Bank, uh, uh, Bangladesh Bank, or BIDA, Bangladesh Investment Development Authority. So in those situations, we enter into the agreement. The parties enter into the agreement. They sign the agreement. However, they include a condition precedent that this agreement will only become effective if this agreement um, obtains prior permission, obtains permission from Bangladesh Bank. So if that condition precedent is not fulfilled, this agreement will not be effective. So that is the condition precedent, a condition which has to be fulfilled in order for the contract to become effective. Conditions subsequent are conditions which comes after the contract becomes effective. So, for example, in our mobile phone scenario, um, uh, the mobile phones would be usable after delivery is a condition subsequent. It is a condition which comes after the contract comes into being. Um, so conditions are very important. If the condition is breached, uh, um, the party would be entitled to damages and would be entitled to terminate the agreement, because this agreement is of no value, because the condition is so important that the agreement loses value if it's not fulfilled. So the innocent party would be entitled to terminate. The next up is covenants. Covenants are things parties promises to do during during the agreement. Covenants are can be of two types. Covenants can be a positive covenant or a negative covenant. A positive covenant would be example is assurance of quality, that I would provide a mobile phone which would be of this certain standard, or it would have a touch screen, or it would have quality which is certified by an independent third party. Those are kind of positive covenants. These are promises that you make, that you are going to do, that you are going to keep during the contract. Negative covenants could be something which you will refrain from doing during the contract. So parties can say that, well, the mobile phone I'm giving you would not be tainted or would not be tampered with when they are provided to you. They would be in an intact. We won't be interfering with the manufactured quality of the mobile phone when we deliver it. In an employment scenario, um, there can be a term which is very common, that when you enter as the business enters into an employment agreement, and the employees have a negative covenant which says that you cannot solicit other employees from my business, and you cannot work for a competing business. Even if you leave my employment, you cannot work for a competing business for this many years. So that is another common negative covenant here that is included in employment contracts. Um, the next one is the next type of terms in which are included in the contracts are the less important terms, but they are terms nevertheless. They are known as representation and or warranties. These are terms which are not fundamental, but they are nevertheless very important. Um, uh, a representation or is a fact, is a fact true on the date of representation when this representation is made. So I had a few years back, I had one agreement between my client, which is a telecom operator, and advertising agency, where the advertising agency represented that it is advertising agency with various connections in the media, and it has this number of years of experience, and they have full capability of providing services to my client, which was a telecom operator. Ultimately, this representation was found to be not true. It was found to be inaccurate. It was not an experienced advertising agency, and it didn't have as many contracts or networks with the media industry. So we had to advise what to do in that scenario. In that scenario, you can go for damages. You cannot terminate the agreement because you're not devoid of the value of the contract entirely, as in the situation of a condition. You get some value, but you don't get the entire value. So you are financially less well off. So you can go for damages. However, certain warranty or representation, if breached, can give you may entitle you to terminate or make the terminate the contract. And this is when the contract itself states that if this is a representation or this is a warranty, however, if this is not fulfilled, we can go you can go and terminate this contract. If the contract gives you that right, you can go for termination. However, if it's silent, it is very likely that if it's a warranty and not of it's not a term which is of fundamental importance, you may only go for damages. This is a example of representation where the one party is saying that I represent that I have power to execute and deliver and perform this the obligations I have entered into this agreement. So this is important because sometimes the company or the party to the contract may not have the power to enter into these kind of obligations. So in that scenario, in those kind of scenarios, these clauses are quite helpful in the sense that the other party, you have no, sometimes it's not possible to see what the other party is capable of doing, or internally what it is permitted to do. So you include this kind of clause in the agreement where the other party will certify that it has the power to enter into this kind of obligation and to perform this kind of obligations. And also that it has all the consents, authorization, and approvals required to enter into this particular agreement. Sometimes it's not possible for, in commercial context, that you go for an extensive due diligence of all the license and permits the other party has obtained for entering into this commercial contract. So you leave it up to them to obtain everything and just take an undertaking or a representation from them in writing that they will or they have obtained all the approvals required for entering into this agreement. This is an example of a warranty where the debtor is, I think this is in a loan context, the debtor is warranting that the collateral or the security it is providing for the loan are all free of liens, claims, or any other encumbrances. So it is kind of saying that, look, I'm giving you fresh assets which will act as security. Fresh assets in the sense it has no other charge over it or liens over it or any other rights of any other parties over it. So that is something you take in addition to doing your due diligence. Usually what happens are banks do certain limited due diligence on the assets which are provided as security, but it is good to have this kind of clause as well, because if it's because this is a limited due diligence which is possible in a everyday loan situation. If it turns out to be untrue, if there are rights over those assets, the banks can go and sue for damages arising from inaccurate or breach of that warranty. Indemnity is a type of this is a separate heading. However, this is actually a type of warranty where um, if the warranty is untrue, the other party says that, look, if the warranty is untrue, I will make good all the losses which flows from this untrue in warranty. So I will bear all the cost. I will bear all the damages, anything which flows, legal cost, any other cost, damages, everything flowing from that breached warranty. So this is a clause where it says that um, uh, these sort of actions will be taken by the breaching party. This is an example of an indemnity clause where each party shall indemnify other parties or hold other parties harmless from against any losses, liabilities, damages, claims, penalties, actions, judgments, suits, etc., etc. Reasonable fees of the council. So if you have to engage a council, that is also covered, which may be incurred by the other party as a result or indirectly or directly arising out of indemnifying parties breach. So the indemnifying party is the party who is agreeing to this indemnity clause or providing this indemnity. So if he breaches, he would be liable to all the costs, as you can see. So that is an example of an indemnity clause. Breach of agreement. Breach of agreement. This is a clause which would set out the scenarios where that contract would be deemed to have been breached. So it would set out this event of default scenarios. So sometimes we call it event of default with capital letters, and that is defined in the definition section of the agreement to avoid confusion. The common event of default scenario are non-payment uh, or default, non-payment of the consideration, default in installments. So that again, this is another way to not pay. Insolvency of one of the parties, bankruptcy, liquidation, merger of a party. Sometimes the parties entering into a contract may not want the other party to merge into another entity. Change of control. This is interesting because sometimes we do not want uh, so suppose you enter into a contract with a company, and suppose that company is Boshundhara Paper Mills Limited, because you want their expertise in tissue paper business, and that is why you enter into this contract. After you enter into this contract, Boshundhara sells off the shares of Boshundhara Group sells off this shares in Boshundhara Paper Mills Limited to some other unknown party. This is the situation you would ideally want to avoid, because they are now leaving you dry with expertise you wanted under this agreement, because they are leaving this company. They're changing the control of this company after you entered into this agreement, and this could be cause of damages or loss faced by you, because you would now lack expertise of Boshundhara Group in tissue paper industry. In that scenario, you would want to have, include change of control of a party as an event of default, so that if Boshundhara Group changes its control in the Boshundhara Paper Mills Limited, you can terminate this contract, because that would be a breach of the contract, event of default. Failure to meet certain performance level also sometimes included in the event triggering termination scenario. Um, sometimes um, sometimes so this is a example of an agreement which provides which deals with termination, and it actually provides, and you'd see, provides that opportunity for cure. And this is also very common in commercial contracts. Commercial contract often provides the parties opportunity to cure these defects for certain period. If it's not cured, then it goes for termination. So you don't have to do it, you don't have to provide the cure period. It's up to the parties, but it is a norm, and it is nice to have. It is nice to have a buffer period so that parties can minimize the disputes. So disputes only arise as a last resort between the parties. Uh, so I've already dealt with some of these. These are termination clause contains circumstances in which parties may terminate a contract. The procedure for termination, so you have to wait, you have to give a notice, you have to wait 15 days, and then you go for termination. A termination can be for cause, can be for a particular reason. However, termination can also be without cause. There are many commercial contracts which provides for termination without cause. And these are termination which is not for any particular reason. The termination is just because the other party does no longer requires the service. In this kind of termination, the notice period is usually a bit longer than termination with cause. For example, if termination without cause, I think um, in this example, for example, there is a 1 month prior notice period. This is an example of termination without cause. You can just simply terminate by giving a notice because you no longer require the product or services. So you terminate the contract, but then you have, if there is a default scenario, and you terminate with cause, and the contract entitles you to terminate with cause, or it does not entitle you to terminate, but either way, you would have claim to damages, whether you can terminate the contract or not. And the damages can be of can be direct damages, and direct damages is something which flows directly from the breach of the contract. So the language that is used in section 73, which is the applicable section for direct damages, is damages which naturally arose in the usual course of things from such breach. So suppose the mobile phone, in the mobile phone contract scenario, the mobile phone were not provided. The value of the mobile phones, you paid for the mobile phone, you provided a consideration, and you had an expectation also to sell the mobile phones at a particular price. If you can prove those values of mobile phones and the price you would make from those sale of mobile phones, you can claim those as direct damages. These damages are awarded by courts on an assessment. So you have to prove those, the quantum of the damages. You have to prove that this is because of this breach, I've suffered a loss, and this is the amount of loss I have suffered. You have to prove and establish before the court before you would be awarded as direct damages. The damages also can be liquidated damages. So this is a scenario where at the time of entering into the contract, the parties agree to an amount or a certain percentage that the other party would pay if there is a breach. Because oftentimes it is hard in certain type of scenarios to prove the damages, prove the actual damages. Remember, in direct damages, you have to prove the damages. The court will assess the amount of damages, and then they will award you the damages. In section 74, you don't have to prove everything. You have to prove that you have a contract, and the contract stipulates that compensation or penalty would be effectuated on the breach of contract, and the sum or percentage is stated in that clause. And the other thing you have to establish is that this is something which was a genuine pre-estimate of the damages that may occur, and the parties acknowledged it. Both the parties acknowledged and agreed that this is the genuine pre-estimate of the breach of the damages which would flow from such a breach. That is something you have to again kind of prove or establish. So a good clause for liquidated damages would include that this is a genuine pre-estimate of the damages. These type of contracts are generally used in construction contract scenario, or real estate development, or even in government contracts. So government contracts, for example, I am dealing with an arbitration where there is a liquidated damage clause, and the liquidated damages clause was regarding the contractor not fulfilling, or in that particular contract was regarding power grid, establishment of power grids in different parts of Bangladesh. If it's not done, it is very hard for the government to establish how much loss it has suffered because it is very hard to show something that has not already happened. So how much money it has lost from the subscribers as income because of lack of power grids, for example. So they agreed to a liquidated damages clause, and it was certain percentage of the contract, and that was being enforced in an arbitral proceedings. This is an example where one of the parties enters into, and the liquidated damages amount is 0.0125% of the amount outstanding per day. So this is a fixed percentage that the party would be liable to pay if there is a breach. And you don't have to kind of prove the quantum in order to claim these damages. Um, this is the last slide, I believe, and this is where you damages itself are not adequate, and you would want, actually, even if the other party has breached the contract, uh, you would want the other party to respect and fulfill his part of the agreement. You can go for specific performance in those scenarios. Specific performance is when you make the other party, so the party has not provided you, in the mobile phone supply scenario, has not provided you with the mobile phones as promised. You kind of go and you could sue for damages, definitely. But what if um, you have promised your gramming phone, and you have promised your customers with iPhone, and there is only one manufacturer in the entire world which produces iPhones, and they are not providing you with iPhones. Yes, of course, you can sue them for damages, but damages would not cover the loss of goodwill that you would suffer in front of your customers, because you promised them you would provide them with iPhones as part of your plan package, but you are now not being able to provide it. So in those scenarios, you may want to make the other party go ahead and fulfill their part of the promise. And this is where you go for action for specific performance. You file a suit and ask for direction from the court that the other party fulfills its part of the promise or part of its obligation under the contract. So, so you have in it. The thing to remember is, if there is a breach of contract, you can terminate it. You may terminate it if it's a condition. If it's a condition, you will be able to terminate it. If it's a warranty, you may be able to terminate it if it is permitted in the contract. But in all scenarios, you would be able to recover damages, and you can also go for specific performance in breach scenario. And this is an example for in specific performance. One of the things you have to show is damages are not adequate. And this is something you need to establish before court. One way we circumvent this requirement, or circumvent or cross this hurdle, is to include a clause in the contract which says damages would, each party acknowledges, and you can see in the example here that each party acknowledges that damages would not be adequate, and the parties would be entitled to specific performance. So if you have this in the contract, this will kind of help you to establish the first hurdle, to cross the first hurdle in a suit for specific performance, which is that in this scenario, damages are not adequate. Therefore, the parties would require a direction from the court, specifically requiring the other party to perform the contract. So, when you include these clauses in the contract, you have to keep in mind that there is a list of things, list of contracts which may not be specifically performed, and court will not give specific performance with regards to those contracts. And these contracts are listed in section 21 of the Specific Relief Act. 1877. That is, these are contracts usually of very personal nature, and the contract term is so vague. It's not of certain nature. So it's not about mobile phone. It was about something which is vague. Court will not give you specific performance on vague contracts. So if the contract is vague, it will not be able to give you specific performance as a relief of breach of contract. So I will stop here and I will hand over to Mr. Saqib Mahbub to deal with some other aspects of commercial contracts, and these are very interesting aspects such as dispute resolutions and very topical in the sense that it will also deal with COVID-19 scenario. So I think I've crossed a bit of I've kind of crossed my time allocation. I hope Saqib is going to be able to make it. So I'll hand over to Saqib here for the rest of the presentation.
Thank you, Zakir. Thank you for taking us through these very important clauses. Let me just set up my screen. Can everybody see my screen? Okay. Sorry. Should start from here. Okay. The first clause that I'm going to deal with is force majeure, which is quite a topical clause in the current scenario because it has now it has implications with regard to the COVID-19 situation. But I'll just go through what it is first. So what happens when a party is supposed to perform under the contract? Either it can be a performance of a service, so it has to do something, provide a particular service, or it has to supply some goods, and so that party is supposed to perform something. But it is not possible for some kind of situation to actually perform, to actually conduct that performance. So for those times, the clause that a party wants to have is the clause of force majeure. So this is kind of this clause describes some superior force events. The term is superior force to describe situations which are out of control of the parties. So if you would see, if you have dealt with commercial contracts, you would see that there is a force majeure clause in most contracts where you would see that certain scenarios are listed as scenarios where the force majeure would come into play. For example, act of God, superseding government actions, natural calamity. If you're in a manufacturing contract, there may be labor disputes, etc. So that is something. These are common scenarios that are put in clauses. One important thing to note for when drafting force majeure clause, and when also in a dispute scenario where you are dealing with the force majeure clause and one party is trying to invoke it, is that the event must be unforeseen. So it cannot be an event that was foreseen at the time of entering into the contract. For example, if you are saying that COVID-19 is my force majeure event, but the contract was signed on the 1st of March 2020, can you at that time say that I didn't know that COVID-19 would come and my factory would be closed, etc.? Can you say that at that point? Probably not. It would be very hard for a performing party to argue force majeure if at the time of the contract they knew that such a situation would happen. Another thing, it has to be beyond the control. So if there is some kind of way that the performing party can actually perform even in that situation. So just because there is a natural calamity or say a terrorist attack, etc., it has happened, doesn't mean that the force majeure can be invoked. That also has to be beyond the control. So the lack of performance, or the absence of the performance, has to be beyond the control of the party which is performing. So if the party can actually perform the contract, even in that situation, it still has to keep its promise and perform. So the the purpose of a force majeure clause, if you're if you're negotiating on the side of a party which is supposed to deliver some goods or services, then you should think about what are the situations which will prevent your client from actually performing what are the out of control situation, what are the superior force situations which will prevent your client from performing his side of the contract. So for example, if your client is a garments manufacturer, you should put in say labor strikes, so that if there is a long strike and there is a delay, that your client is not liable for that. And then it should be specified as much as possible. So you should cover as many situations as you can. If you're negotiating on behalf of the client who is supposed to perform in this contract, so as many situations as you can to cover the situations which will prevent your client from actually performing the contract. Another thing to note is that even in the situation, say it's very difficult to perform a contract, is that enough for a party to say, hands up, sorry, I cannot perform it because this situation which we had listed in our force majeure clause has happened, so I cannot perform the contract anymore. It's still not enough for that party to say that. That party still has to show that it made reasonable efforts to mitigate that scenario. So for example, if the government has banned, if the government is preventing you from starting your factory, but is saying that you can start your factory if your workers are wearing PPE and they are at a distance of 6 feet from each other, then you cannot say that, COVID-19 happened, it was in our force majeure clause, so I'm not going to perform it. Then you have to actually go and buy some PPEs for your workers and make sure that you're still doing the work. Just because it has become more costly for you doesn't allow you to invoke force majeure clause. Just because it will take more time for you doesn't allow you to invoke force majeure clause either. So a burning question now is around the world is COVID-19 a force majeure event? There is no straight answer to that. I would invite you to comment in the chat box if you think it is, or if you think it is not. You can say yes or no, and we can take that up in Q&A. But just to give you some context, something that has happened in India. We have some Indian friends joining in this call, so they may correct me if I'm wrong. There has been a notification from the government that in government contracts, for the purpose of government contracts, force majeure has been included as a natural calamity. So if there was a contract with the government which had a force majeure clause which had natural calamity as one of the situations where force majeure would be invoked, then COVID-19 could be interpreted as a natural calamity. So this is an example of a force majeure clause. This is, I think, quite a well-drafted example. These are all the samples that we have shown are all from real life contracts. And this one, I think, is pretty good. It covers quite a few things. It covers, if you see, it covers situations like, I think, strikes, work stoppages, accidents, acts of war or terrorism, civil or military disturbances, etc., etc. Doesn't cover COVID-19, obviously. At that time, it was not present. And you will also see towards the end that the trustee here, one of the parties, shall use reasonable efforts which are consistent with accepted practices in the banking industry to resume performance as soon as practicable under the circumstance. So you're, as the party who's supposed to perform something, you're under an obligation to take all the reasonable steps to actually start your service or production, whatever, as long as you're as soon as you're allowed to do so. So as I said in the previous slide, that you have to take reasonable steps to mitigate the situation. You cannot just you say hands up, I cannot do it because of force majeure. Going to the next slide. Okay, so one clause that is it appears again, another clause that appears in most contracts would be, is anyone having difficulty hearing me? Okay. So another clause is governing law. So governing law is, what is the governing law of a contract? So it basically, as you know, if a contract is governed under Bangladesh law, the Bangladesh Contract Act applies, and years and years and years, years and years of decisions from the judicial pronouncements to interpret the Contract Act and contractual terms apply to that. So if you've chosen Bangladesh law as the governing law, then you're kind of getting that whole package of not just your statutory law, but also the judicial pronouncements and precedents. So this is your time as a party or as a advising lawyer to decide which country's law will be applicable. This is usually a case, and usually only a case when there are parties which are from different countries. So if it is a cross-border agreement, that is when the negotiations have to happen. Which country's law will apply in this? And so it's say a Bangladeshi company and an Indian company. Then the Bangladeshi company and the Indian company will sit and decide if the Bangladeshi law will apply, or the Indian law will apply, or a neutral country's law can also apply in a cross-border agreement. So, for example, one of the most common neutral countries that are used is England and Wales. So, doesn't even in situations where an English party is not there, two parties will come and decide that our contract will be governed by English law, because English law is quite popular, because there's lots of countries around the world. There are lots of lawyers and judges around the world who have been trained in England and have knowledge of English law, and it is taken to be quite a internationally acceptable set of laws. In our region, the laws of Singapore, for example, are sometimes used as a neutral country's law. So this governing law is actually will govern the interpretation of how your contract will be interpreted, and in that sense. So that is moving on to dispute resolution. So dispute resolution is a very interesting clause for particularly lawyers who are also practicing disputes like myself. So who do litigation and arbitration. It's a very interesting clause to look at, and we often spend a lot of time drafting it and negotiating on it. So there are in this dispute resolution clause, you're trying to decide what will be the mode of resolving disputes if there are disputes within the parties. Usually, in most cases, it will be either litigation or arbitration will be the main dispute resolution mechanism. There are also other dispute resolution mechanisms, for example, adjudication and mediation. Adjudication you will see mostly in construction contracts, government construction contracts. Mediation, nowadays lots of people are using mediation as well, but usually it will be in conjunction with either litigation or arbitration. So say in a government construction contract in Bangladesh, you would see that the dispute resolution clause would first say that parties will have to first try to resolve the dispute amicably, and if it is not possible to do so, then they will go for an adjudication, and if not, if that doesn't work out, then we go for an arbitration. So arbitration is quite common nowadays in our government construction contracts, and in commercial contracts, particularly If it is a cross-border contract, arbitration has a lot of advantages over litigation because arbitration awards are much easier to enforce all around the world than court judgments. So, for example, um, uh, I think about 167 countries are part of are signatories to the New York Convention. So, if there is any arbitral award from one of the New York Convention parties, then any other state in the who has signed up to the convention is under an obligation to enforce that our arbitral award. That is not the case with litigation. Litigation, if you have a court judgment, then you have to have a bilateral treaty between with another country, which will allow you to enforce a judgment of the court. So if your dispute resolution mechanism of choice is litigation, then it's quite simple. You choose the forum where the dispute will be heard. So you will simply say that the courts of Bangladesh or the courts of India, courts of Thailand, we shall have exclusive jurisdiction over all disputes arising out of this agreement. As you can see in the example, it's quite simple, and it can be a very short clause. If it's arbitration, then it actually there's more points of negotiation and more things to think about. For example, the first thing that you may think about is seat. So the seat of the arbitration. Arbitration is actually a very vast topic, and it's quite unfair that I'm covering it in such quick time. But we don't have that time for this session. But in any case, so seat is basically the country or the state which has supervisory role over the arbitration. So for every arbitration has if the seat of the arbitration will where the seat is, that seat's court will have supervisory role over that arbitration. So for example, it can hear interim applications. It can hear, so in Bangladesh, if the seat is in Bangladesh, Bangladeshi courts can hear applications for interim injunctions, etc., and attachments and things like that. Also, which court will hear the setting aside application. So that is also decided when you decide seat of arbitration. The venue of arbitration is usually the same as the seat, but can be different. So the venue is actually the actual physical place where the arbitration is going to take place. So usually you don't name the exact building where it is going to happen. You name the city. If it is an ad hoc arbitration, you name the city where it's going to happen. So you can say Dhaka, Bangladesh is the venue. It will take place in Dhaka, Bangladesh. Then is the language of the arbitration. If it is a cross-border contract, you will almost always say it's English. The language is English. In Bangladesh, even within Bangladeshi parties, I have not seen yet where parties have decided on anything other than English as the language of their arbitration. So in what language the arbitration will be proceeded. Another important factor to consider is institutional or ad hoc arbitration. So ad hoc arbitration is simple in a way. The drafting of the clause is simple, at least. Ad hoc arbitration is when the parties themselves will actually decide the rules of the arbitration, the timelines. It will decide where exactly will it sit, how the tribunal will be appointed, etc. So that is an ad hoc arbitration, and that is actually the most common type of arbitration clause as well. I'll show you an example a bit later. Another type is institutional. So institutional arbitration takes place under the supervision of an institution. So it's usually an arbitral institution, or it can be other trade bodies as well do institutional arbitration. So in Bangladesh, the only specialized institution is the Bangladesh International Arbitration Center, BIAC. There are others in the region. For example, in Singapore International Arbitration Center is quite famous. The Mumbai International Arbitration Center, I think, is coming up is rising right now. In China, there is CTAC. So there are in London, there's the LCIA, I think. So these are the common institutions that you can go for if you want to have a institutional arbitration. So another thing that you decide is number of arbitrators. So if it is especially if it is an ad hoc arbitration and you're going to decide on how many, you can decide how many arbitrators you want. You can have usually the usual number is either 1 or 3. So if you want to cut costs, so keep things simple, usually I would say go for a sole arbitrator, because sole arbitrator means there's only one arbitrator to pay. Arbitration can be a very expensive affair if you're having to pay 3 arbitrators, but sometimes parties do prefer to have 3 arbitrators because they want their say in the tribunal. So if it is a 3-member tribunal, then one party would appoint one arbitrator, another party would appoint another arbitrator, and the two arbitrators would then appoint an umpire or a chair who will lead the tribunal, and ultimately will have the casting vote if there is a tie between the two. So that is another consideration when drafting the arbitration clause. So all these factors will actually come in when you are drafting or negotiating the arbitration clause. This is an ad hoc arbitration clause example. So if you see the first sentence here, it is actually just saying that the parties will try to settle their disputes within 30 business days of the dispute arising. But if they are unable to resolve the dispute, then it will be they will go for arbitration under the Arbitration Act of 2001. So that's the Bangladesh Arbitration Act. So it is this one is very much an ad hoc arbitration where they have not even decided on the number of arbitrators, but this is they can decide it later on. This is an institutional arbitration example clause. So this is the clause that is actually recommended by BIAC, the Bangladesh International Arbitration Center. So in this one, the parties have decided that their disputes will be finally settled under the rules of arbitration. So the BIAC has a set of rules where they have timelines of how the arbitration will work and how it will go, the language, etc., and specific formats of how things go. So in this one, you are kind of submitting the dispute to BIAC for them to resolve. But the seat of arbitration, you're mentioning that it will be in Dhaka. Moving on to confidentiality. I'm seeing some questions, but I'll try to go through and then address the questions and the Q&A time. Please hold on to them, and definitely they're saved in the chat box, so don't worry. So the confidentiality clause. This is a very important clause if the parties are dealing with sensitive information or exchanging sensitive information, which shouldn't go to the public and the public shouldn't see it, or if it can be used to do some harm, or it can be used to compete, or it doesn't make business sense to reveal these informations. It is also known as the non-disclosure clause, and it can you will often also see it forming a separate contract altogether. It can be part of the main contract, but it can also form a separate contract altogether. It's you will hear the term NDA. So it's called a non-disclosure agreement. So the purpose is the same. Doesn't matter if it's in your main contract or if it's in a separate contract. Sometimes even what the parties will do is that even at the negotiation stage of the contract, they'll first sign an NDA just to protect themselves, because at that they will be revealing information at the negotiation stage, and they don't want this information to go out, even if they don't enter into the substantive contract later on. They don't want this information to be revealed, so they enter into an NDA beforehand. But if there is as I said, it can also be part of your main contract, so that it will be a confidentiality clause. It can also what will usually happen also is that it will not just apply to the parties themselves. So the parties can be the companies that are coming and getting into a contract, but but you can, as one of the parties, you can insist that not only should you insist to the other party that not only should this confidentiality clause apply to you, but it should also apply to your present and future employees during the duration of this contract, because the employees will be dealing with this information, and they can also leak the information either when they are in employment or once they are out of employment. They can also leak it. So you have to make sure that your employees also don't leak it. So if you will be liable if your employees somehow leak it as well. Another thing is that its confidentiality agreement, it will survive the termination of the agreement. So what does that actually mean? We'll go into survival clause towards the end. We're not too far from the end anyway. But confidentiality clause is one of the clauses that should survive the termination of the agreement, and that should be specified in the contract as well. It will not survive the termination of the agreement if it is not specified. So what does it actually mean, surviving the termination of an agreement? What it means is that even when the contract has been terminated, either mutually or one of the parties have terminated it, or it has naturally come to an end, even then the confidentiality clause will survive. So if, say, you have, say, a telecom operator has gotten into a service agreement with an outsourcing service provider, and the telecom operator is having to provide some confidential information such as customer data. But at some point they realize that the relationship isn't working very well, so they decide to terminate it. So if at that point, obviously they went into a confidentiality agreement as well within the agreement, that you will not use this, you will not disclose this data that you have. So if the confidentiality obligation finishes at the point of termination, then the outsourcing agent, he's free to disclose the information. But that, obviously, we don't want that to be the case. So if I am advising the telecom operator, I would say that the confidentiality agreement should survive at least a few years after, or even perpetually. Just because you have entered into this contract, you will never ever disclose the information that you have received under this while working under this contract. So even if the contract is terminated at some point. So this is a very important thing to note when you are drafting a confidentiality agreement. This is an example. I think it does take account of the perpetually surviving it. If you see the last line, the obligation of the confidentiality hereunder shall continue throughout the term of this agreement and survive its termination. So it will survive its termination perpetually. You will also see in the middle portion that each party shall use their best efforts and take all appropriate steps to ensure compliance with this clause on the part of their present and future directors, officers, and employees during and after their term and the term of employment. So you're putting a binding obligation on them to make sure that all their employees and directors are all are following the confidentiality obligation. This is a clause. It's not as common as the other ones that we have seen, but it is a useful clause to have. It's called a no waiver clause. It can be called in other names as well. But what it means is that if say there has been a breach of some kind by one party, but the other party has not taken action against that, or has not written to that other party saying that, oh, you have breached it, so now you have to cure it, etc. That notice has not been given, or no action has been taken. So in these times, the party which has breached the contract may come and argue that, oh, I breached the contract, yes, fine, but you didn't say anything. So you waived your right to say anything. You waived your right to protest against it. You waived your right to claim damages. So this is to cover those situations so that the breaching party cannot come and say that the right to take up a dispute, the right to claim damages has been waived. So here the parties are agreeing that even if a right or remedy hasn't been exercised on time or within a certain period, it doesn't mean that it has been waived. It will still be there. And another thing is, it can also say that, okay, one type of remedy has been sought, but another type of remedy hasn't sought. So you have already asked for one remedy, you cannot ask for this remedy, the second remedy. Uh, this clause also takes account of that fact, that just because one remedy has been sought for doesn't mean another remedy cannot be taken. So if you see the example, I think it covers it, that no failure or delay on part of, say, party X in exercising any power, etc., shall operate as a waiver thereof. So just because they haven't taken, they have failed or delayed to exercise a power or right, doesn't mean it has been waived. And I think a single or partial exercise of any power, right or remedy, will not preclude any other further exercise of power either. Another common clause is the entire agreement clause. So the entire agreement clause will not be long usually in contracts. So the entire agreement clause, the purpose is to state that whatever is in the contract, whatever is in the four corners of the contract, that is the contract. There is no other document or any other material which should be used to interpret the contract. That is what the entire agreement clause is saying. So, what will happen in a practical situation? Why will this be important in a practical situation? For example, there is the parties are, before signing the contract, before drafting the main agreement, they have lots of email exchanges where where the one party is promising a variety of things, and other party is also promising a variety of things, and they may even get into an MOU, which I think most of you will know that it is not a binding document. So they have all these documents: email exchanges, phone call records, meeting minutes, MOU. So what happens to these documents? So when you come to the agreement signing stage, you want to say that whatever I have stated in the agreement is what I'm going to do, nothing except that. Whatever I said in that email before is not a part of the agreement. Whatever I said in the MOU is not a part of the agreement. What I said in the mandatory terms of this agreement are what I will do. So this basically ensures that there is no dispute over, like, oh, you called me and said that we'll do something else, and etc., or you emailed and we had an MOU which said something different. So it is to exclude everything that has happened in the past, and to say that whatever is in the whatever representations and warranties and obligations and whatever terms are there in the contract, that is final, and this is it. There's nothing outside of this. So this is a very basic entire agreement clause, but it does the job because it says that this agreement, if you can see the screen, this agreement and the documents referred to in it constitutes the entire agreement and understanding between the parties relating to the subject matter of this agreement. So there is nothing else apart from this agreement which talks about the rights and obligations of the parties. So this is, if you're if you're advising your client, it's a important clause to have in order to safeguard your client from later disputes where the other side can come and say, oh, something was promised to us in that meeting on that day. So that these situations don't happen in a dispute situation, you have an entire agreement clause. Moving on to notices clause. So this is a very, it can be a very boilerplate clause. You can copy paste and whatever. So this notices clause is actually it shows what actually, how actually the notices which are required under the contract are to be served upon each other. How will the parties communicate with each other officially? So in one of the examples that Zakir was showing, if you remember, is that there was if there was a breach, then the party in that clause, there was an obligation upon the victim party to notify the breaching party that you have and asking them to cure the breach. So that is, for example, a notice that is under that contract. So how will these notices be sent? So this clause actually specifies how these notices will be communicated between each other, and it can say, email. It will specify the modes in which the notices should be received. In some contracts, you will see that also that a specific email is given to serve notices, a specific address is given. Sometimes even a specific employee is named in the contract as the contact person, or his designation is named, and it is the parties agree that any notices between the parties have to be between these two persons. So if it is sent to someone else, then it will not count. So it has to be sent to this person exactly, or it has to be sent to the managing director or any other responsible person. So it has to be that can be specified in the notices clause. Another one is the amendments clause. So the amendments clause is kind of like the entire agreement clause. So the entire agreement clause rules out everything else that has been said before the contract. The amendments clause formalizes how the parties will amend their obligations after the contract. So this deals with what happens after the contract as opposed to before the contract. So the amendments clause will actually say how, will say how how this contract can be amended. Usually it's quite simple. It's written in 2 lines. It can be more, but it's usually what we put in is that it has to be in writing, and it has to be by mutual consent of both parties. So it cannot be oral, it cannot be in any other way, and it has to be both parties have to agree to the amendment. So if just one of the parties is saying that, oh, sorry, I cannot supply you 10,000 mobile phones, I can only supply 8,000, no, it will not work. It will be a breach. So both parties then have to agree that, okay, it's fine, 8,000 mobile phone is fine, but that has to be in writing, and then both parties' consent has to be evidenced, usually through a signature. And it can be in the same way. Usually amendment of a contract is also stamped in the same way as a contract. So this is as just like the entire agreement clause, this is also an important clause to make sure that there is no other form of communication between the parties that is forming part of the contract. So just a phone call or an email saying that, oh, sorry, we let's change that part of the contract, and that these things will not work. So it has to be in a formalized way, and there has to be an amendment agreement or something like that to ensure that the proper record is kept of this amendment. So as I talked about the survival clause a little bit when I was talking about confidentiality. So survival clause will usually list the clauses in the contract which will survive the contract, so to survive the termination of the contract, even if it is expired or terminated, the survival clause will stay. So one example I already discussed is confidentiality. Another can be non-competition. So say, for example, I think we're not doing very good for time, but I think this is, I think I'm only a couple of minutes left. So, and we'll extend a little time for Q&A as well. So no worries. Thanks, Rifat, for reminding me. So the survival clause can have these, will usually name the clauses in the contract. It can be in the form of, they can say that the confidentiality clause, non-competition clause, etc. will survive the termination, or it can even just mention the clause numbers that will survive. So it can say clauses 7, 14, 19 will survive the termination of this agreement. So this means that even after the contract is terminated, these clauses will still survive. So you cannot terminate these clauses. So confidentiality obviously is a very big one. Another can be non-competition. So for example, if you want if you have, say, going back to the example of the telecom operator. So this party has worked with you for a long time in a contract. So you want, and then that party suddenly terminates the contract, and he has all the expertise of a telecom operator, and he can start. Obviously, it's not easy to start a telecom operating business, but say if say it's a restaurant business, and then you have a supplier, and you don't want that supplier to open a competing business with you. So this non-competition clause usually will be for a limited time. Usually, it's not for perpetual time. It will be for a limited time, and it will be for a limited geographical territory as well. So you will say that, okay, you will not open a competing business for 5 years in Bangladesh. So if you want to do it somewhere else, then fine, because you're not competing with me, but not in Bangladesh. So I have an example which explains what I have said, so I will not go into it too much. Another clause is the severability clause. It's usually doesn't come into play too much when in terms of in dispute situations, but it's a clause that can be useful to put in your commercial contract. What this clause does is say there are some performances which need to be done under the contract, and one of the performances is actually not allowed under the laws of Bangladesh or whichever country where the performance has to happen. Then what happens? Is the whole contract invalid? It can be, but that is if the parties have chosen a severability clause or put the severability clause in the contract, then what will happen is that only the part that is not legal or not enforceable, only that part, so the rest of the contract will be severed as in cut off from that part and will still survive. So the whole contract will not be invalidated. Only that part which is invalid or unenforceable, only that part will be invalidated. The rest of the contract will still survive. So this is an important clause to have if you have different types of performances in a contract. Say you're picking, you have service A, service B, service C in a contract that needs to be provided. And it turns out that service A is not valid, or you didn't, it's not possible to do service A. So then instead of just saying, oh, this contract is absolutely useless and invalid, you are saying that, okay, fine, service B and C will still be have to be done. So that is the purpose of the severability clause. This is an example of a severability clause. It doesn't say much more than what I have said, so I will not go into the example, and we are also running out of time. Next is the costs clause. This is quite easy to understand. The question is, who will bear the costs of the agreement? So a commercial getting into a commercial agreement can be costly. If it is a big contract, you're paying your lawyers, and there can be other costs. So who will actually bear the costs of this agreement? Usually, if the costs are not too substantial, then the parties will divide up the costs between themselves, in the sense that each party will pay its own costs for the agreement. But if there are, for example, like there are other things can come into it, for example, taxes, stamp duties, if there are substantial stamp duties. For a normal commercial contract, the stamp duty is almost nothing, 300 taka. But for say a share purchase agreement, that has the stamp duty there is a substantial part of the value of the shares. So it becomes so then in those situations, it is important to divide up who will actually bear the costs which are related to the agreement. So I think, yes, we have come to the end of our session, and it is Q&A time, and I will I have closed my screen so that I can read the chat window. I will just, I noted down some questions that were coming up during Zakir's presentation. So I'll just put that to Zakir. Zakir, are you unmuted? Okay, let me unmute you. Yeah. Okay.
Yes, I think I can
So,
talk now. Yeah.
okay, Zakir, have you gone through any of the questions in the
Yes, I
chat box?
have gone through
Okay, you
some
want to
of the
answer?
questions which were made
Yeah.
during my presentation.
Yeah.
One of them was, I think it's
I think,
from MD Himail
yeah.
or Rashid.
Yeah, I think he may asked about gambling.
Yeah, so I think he asked about other games, other
Yeah.
games other than gambling, and if a BD company provide online card games mobile ad for BD customer, so it's a BD to BD, okay, and customer can use money to buy some tools to play a game and can pay through payment gateway, and there is no gambling and wagering. I think in this scenario this should not be a problem. If there is no gambling or wagering, because the Bangladesh Bank circular, which I'm talking about, came out last November. This is April, last November. I think it was on 24th of November 2019, and that only asked the banks to make sure that the payments are not made in relation to gambling related games and lotteries and other prohibited items like foreign investment in shares made by credit cards. So those were the prohibited items. So I think if it's a game given by a Bangladeshi company to a Bangladeshi customer and the game has no elements of gambling on wagering, it should be fine. It is fine.
I think another question from Megha was if stamp duties aren't paid, who pays the penalty? I think that was the first question to be made.
Oh, I think I skipped that. Okay. If the stamp duties, if the agreement is silent on the stamp duties, there is a section in the Stamp Act, I think it's section 29, and it lists a set of contracts. So the answer to your question would depend on what kind of contracts we are dealing with. So if, for example, if it's a lease agreement, then the lessor would end up paying, because it's stated in section 29 that for lease agreement, if there's nothing else in the contract, the lessor would pay. So there is a list of agreements there where it is provided who would be paying the stamp duties. Yes, it's section 29. I just checked. Okay.
I think another question was, can covenants be considered as conditions subsequent?
Covenants are promises which are made regarding performance. Condition subsequents are very important terms of the contract, and they are if they are so important and so fundamental to the contract, is if they are breached, you almost get nothing from the contract. So these are so important contracts. So while these are promises, covenants, if you breach it, you would be breaching one promise, you would be not honoring one promise, but it would not mean that you are not getting anything out of the contract. So that there is a distinction between this, and in terms of seriousness, and how fundamental it is to the contract.
I'll answer while Zakir, if you could scan through the comment box and see something that applies to you, and also if you want to add into what into my answers. I think there was one question whether force majeure clause can include a pandemic, and if a pandemic is include, the word pandemic is include, can COVID-19 come into it? I think that's quite an easy question to answer. The World Health Organization has declared it a pandemic, so it would be probably quite easy to convince the court that COVID-19 is a pandemic, so it's a force majeure situation. Another clause was if an example was given of a European supplier and how to what a Bangladeshi sorry, was that a European supplier? Sorry,
Want to
I,
breach
I,
the contract due to.
where's the question? Not
Oh,
quite.
so I think this question means that the European supplier wants to argue that COVID-19 is a force majeure. What is the remedies for Bangladeshi counterpart?
Right. So it actually will depend on the contract, as I said, whether the contract, the force majeure situations cover cover this current pandemic as a force majeure trigger. If it does not, then unfortunately no. If the contract, the clause doesn't cover it, then unfortunately it will not be they will not be able to rely on force majeure. And then even if they can rely on force majeure, there has to be mitigation. They have to show that they have tried to mitigate all and the loss or the performance and they've tried to resume production as soon as possible, or they've tried to find other ways of performing the contract while that situation was happening. Another question was, I'll take another question. I think Zakir, you can take the next question that we find. Another question was, in the context of Bangladesh, what's a good dispute resolution clause? Should we go for litigation or arbitration? It's a interesting question because in all the arbitration seminars and workshops, they will always say, why not arbitration? Go for arbitration. You should definitely go for arbitration. But in Bangladesh, in the Bangladeshi context, arbitration in a local context, but the arbitration can add an extra stage to the dispute resolution mechanism, because your arbitration is then, because the courts are not very attuned to enforcing arbitral awards without actually hearing them like appeals in the setting aside stage. When it goes to a district court, and then they kind of take a long time to actually hear setting aside applications, and that goes up to the High Court, the appellate division. Sometimes it's just ADR has been termed colloquially as additional dispute resolution as opposed to alternative dispute resolution. It's a hard question to answer what to go for, but I personally prefer to put arbitration clauses in my agreement, because I find arbitrations, the possibility of actually resolving a dispute is much higher. If you're resolving it in quick time is much higher if it's an arbitration. If the parties can afford it, then it is obviously more expensive than litigation. But if the parties can afford it, then go for arbitration. It is a secret. It is held in confidential space. You can choose your time and etc. And the parties can have a much bigger role in actually, they can sit there in a comfortable environment. So, if your party can afford it, definitely go for arbitration. Zakir, you want to take up a question?
Oh, yeah. So the next question was about governing law and how to decide which governing law should apply in a cross-border contract, and what are the key considerations. I think when there are two parties with different nationalities, each party would ideally like to have their own law as their governing law. But usually in commercial context, what happens is, I think Saqib mentioned it somewhere during his presentation, that they go for a neutral governing law. And English law is one of the more popular ones because of its depth and familiarity all over the world. So usually the parties end up agreeing to a neutral governing law clause. Does the choice have a bearing on where the parties can start litigation process? No. This is the choice of law clause. So choice of law clause would determine under which law your contract would be interpreted. Then there is another clause which I don't know if Saqib include. I think he mentioned somewhere. Yeah, this is the choice of jurisdiction. So if you have a clause which says that all disputes would be resolved by a particular court, that is something you can do as well. Bearing in mind, you cannot completely oust Bangladeshi court's jurisdiction by contract. So even if it says, if the contract says these disputes would be resolved in Singapore under Singapore law, Bangladeshi court still would have jurisdiction, but in that case, Bangladesh court would have to interpret the contract in Bangladesh under Singapore law, because the governing law clause is in Singapore. So the question now becomes, how do Bangladesh courts interpret the contract under Singapore law, because the Bangladesh court doesn't know Singaporean law. In that case, the issues regarding Singapore law would not be issues of law. It would be issues in fact. So you would adduce evidence from Singapore law experts that what would be the position under Singapore law in front of Bangladesh courts. So that's how it would work.
I'll take a question. Uh, Someone asked, I think, Raki. Sorry, I cannot remember who exactly, but the question was, what happens to communications after? So the entire agreement clause deals with communications before the agreement. So what happens to if there are communications after? So that is dealt with by the amendments clause. So unless you have amended your contract, amended your obligations in line with how you're supposed to amend it as part of as written in the amendment clause, then your no communication is valid. So that is the purpose of the amendment clause, actually, to put it in the contract, so that you know that even if there are communications after the signing of the agreement, they won't count for anything unless they are in the form which is prescribed in the amendments clause. So it has to be in writing. If you can say that it has to be writing, you can say that it has to be signed. You can say that it has to be by the mutual agreement of the parties.
So I'll take the next one. I think there is a question from MKI Choyon. And he says that there's an arbitration clause providing for arbitration in London, and it's part of the main agreement. And the main agreement says that the governing law, the agreement would be governed by laws of Bangladesh. Then there's no problem. The arbitration would take place in London, but the contract would be interpreted as per Bangladesh law. So, however, nothing is mentioned in relation to governing law of the arbitration clause. There is no separate, usually there is no separate clause for governing law um, of the arbitration clause. There is a governing clause, a governing law clause of the agreement, entire agreement. So if the agreement in your particular case, if the agreement says the agreement would be interpreted as per Bangladeshi law, and the arbitration, any disputes would be resolved in London by arbitration, then the arbitration would happen in London. However, the the agreement would be interpreted, including the including all the terms and conditions would be interpreted under Bangladesh law in London.
I'll take a question from Rakib, which is quite a very interesting question. It's what will happen if parties breach the survival clause? So if assuming that the situation is that the contract has been terminated and then one of the survival clauses have been breached. So say a confidentiality agreement has been breached. What will happen in that situation? So in that situation, actually the dispute resolution clause, if there's an arbitration clause, that will actually still survive. So the arbitration, so you would go for, if there is an arbitration clause, then you go for arbitration. If there is litigation, then you go for litigation. There's no problem in doing that. Zakir, do you want to take?
The next one, I think, is from Mushtaq Ahmed, and it's regarding force majeure. You want to take that?
Sorry, I didn't read it. I was.
Oh, sorry. So okay, I'll take that. Okay, I have. So he has. Mushtaq Ahmed has been working in a company with as a legal head and has agreement with 250 vehicle owners. I don't know what kind of company this is. In the agreement, there is no such clause as force majeure, but it is mentioned that the agreement will be governed by laws of Bangladesh. Fine. Due to lockdown, all vehicles remain idle and useless. Management decided not to pay monthly rent. So, do you think it will be valid under Section 56 of the Contract Act? If so, I think this also boils down to what Saqib was saying about COVID-19 regarding its status as force majeure event. So I don't know how the contracts. It is a very particular scenario question, and we would have to look at the contracts first of all, and we would have to look at the specific clause which covers the force majeure event. And and as Saqib said, if a lot depends on how the force majeure event has been drafted. If it includes pandemic, and if these contracts were made before COVID-19 was came into being, then there is a high likelihood that they would be able to argue that a force majeure event has occurred. Otherwise, if, like Saqib said before, then if these some of these agreements have been made after um, uh, COVID-19 scenario, then it would be very unlikely. But this is a very particular scenario. But all generally, the position is this: we still don't know a definite answer regarding COVID-19 status as a force majeure event. However, there are arguments which could be made depending on the type of the force majeure clause and when the agreement was made.
I think a very interesting point was made in that year. Whether you have to pay rent during whether rent can be not non-payment of rent can be excused by force majeure. My answer would be no. You cannot say that I cannot pay rent because of force majeure unless you are physically blocked from actually going with the money and depositing it in the bank account. You cannot say that you cannot make this rent payment. So force majeure would excuse performance such as, so for performance under the contract. So we say you have to produce something, you need to deliver something. Okay, if you can't do it, then force majeure can excuse that. But force majeure will not excuse you from making payments. That will not be something that force majeure will cover. So any payments.
So I think in this particular scenario, I think the rent was regarding their property, and the agreements were regarding the vehicles. So these are two separate contracts.
Two separate issues. Okay.
Yeah, maybe these are, so you cannot use force majeure clause available in the contracts for the vehicles for payment of rent. So that is another point.
I think Nahid has made a very good point, and I think she is right that force majeure is not a a statutory excuse or a blanket excuse that you have. It has to be mentioned in your contract. It just because so if there was no force majeure clause in your contract and then you have failed to perform, the other side can very well claim damages, and you will not have an excuse to not have performed unless you have force majeure, unless you're covered by your force majeure clause. So your force majeure clause in that sense is very important. I think we can talk all night about force majeure, and there are many sessions and webinars I've seen for which are just for force majeure. It's such a big topic right now, but we are already way over time. So I would like at this point I would close the session. And I would like to thank everyone for the very good questions, for staying with us for almost 2.5 hours. And I know it's late evening, so special thanks for that. It has been a very good number, very good response from you guys. And I hope this session was useful to you. I hope you stay safe and your family stay safe. And I hope we can come out of this crisis situation very soon. Zakir, if you want to have a few parting words.
Yes, I want to thank everyone for attending. And I think this is the new normal. And if you see, every cloud has silver lining. I think these kind of sessions are the silver lining in the cloud. because these kind of sessions have exploded. The number of sessions have exploded, and I have attended myself attended 3 yesterday, and I've started one now, and I have another one in where I will be a listener in few hours. So I think this is the silver lining, and this is a moment of great opportunity which we must grab, and we should come out on the other side shining. And thank you very much for everyone for listening to us, and hope this was helpful to you. We have the email addresses in the last slide. I think if you want to contact us, you can after this session.
Just so if anyone wants to, yeah. So these are our email addresses. So if anyone wants to just have any other questions or clarifications you want to ask us, feel free to ask. We'll just keep it there for 5 seconds, but it's good night from us.